morning.
Please the court, Adriana Condortese for the defendant, appellee Gerald Eddington. The defendant contends that the motion to suppress evidence should be, the affirmation of the motion to suppress evidence should be affirmed because the decision to impound the vehicle was not justified by sufficient attendant circumstances. In fact, it wasn't really justified by any attendant circumstances.
Well, if you can tell me what you think the police should have done under these circumstances.
Well, it was a 1999 Nissan Sentra that there was no report of theft or anything like that. The car was legally parked. Judge McDonald noted that it was legally parked in an area that he knew as a residential area. It was at least 2 blocks away from the house that the police were observing.
Doesn't the Commonwealth say this was a high crime area?
Well, no, the Commonwealth said that 3 blocks away, that house created some crime. The only other crime the police referred to in that area that was back there were parking violations.
Okay, but apart from the high crime area, let's assume that Judge McDonald is correct, that he doesn't credit that. We still have the owner may or may not know that his or her car is where it is. What should the police do? Should the police just leave it there and just leave it there indefinitely for days, weeks, months at a time?
Well, I think daybreak was an hour or 2 away. It was going to be daytime in an hour or 2. I think that under those circumstances, if they had done some meaningful consideration of the circumstances, like we saw in the Ellerby case, where this police officer knew the neighborhood, he knew it was really in the best interest
but I think the question goes to Mrs. Rodriguez. Ms. Yes. Rodriguez, who they get her name. I take it that they must have run the registration and found her name, but that's all we know. So what should they do?
Well, we know that the car hadn't been reported stolen. We know that they didn't bother to try to call her, and I think that's
I believe that it said that they thought that it was not the right time to call her.
4:30 in the morning, right? But why? And I think this is the reason why I felt so indignant in the application for further appellate review. Why can you not inconvenience a person by calling them at 4:30 in the morning, but you can inconvenience a person who's obviously poor? She doesn't have a very nice car. It's at least 10 years old. Why would you be willing to inconvenience her to tow her car away?
Okay, well, that's my question, I guess. So you're saying what the police should have done then is it should have called her?
If they were going to tow her car, if they felt that it was that.
Yeah, so they should have called her, and if they did not reach her, what should they have done?
I think if they had just asked Mr. Eddington what the circumstances were, they may have found out, look, this is my sister's friend's car, that's why.
But why should they believe what he says? He doesn't have a license and he doesn't have the registration for the car, so the likelihood he's going to make up some story to cover that. I think that besides the issue of a pretextual search, the other issue that really bothered me about this case was the cavalier attitude I think the government is taking towards impounding a car. It really has. I put in my application for a further appellate review that a vehicle impoundment it's really different from any other government intrusion because of the direct and immediate financial impact, not only direct but also incidental impact that it has on the car's owner. When a person is arrested, their life doesn't end. They might get bailed out the next morning and they might still have to be at work in a day or 2. It wasn't his car or Ms. Kappas's car.
I think that even makes it. I think that even makes it worse because now they've taken a person who is completely not culpable and just stuck her with, maybe a $200 retrieval fee. She's got to figure out a way to get down to the tow yard.
If she lends a car to someone who doesn't have a license and she doesn't find out that the person doesn't have a license, isn't she sort of taking the risk?
Well, what, taking the risk that her car is going to be towed away?
No, that the guy's going to get stopped and discovered without a license. I mean, you shouldn't lend your car to somebody who isn't licensed to drive.
That might be the case, but I don't think that police towing your car is a fitting punishment for that, for bad judgment.
We want to give some rules to the police for the future on what they should do. So,
Yes.
So what are you saying they should do? They should make an attempt to telephone the owner?
Well,
That's the first step?
Well, I think that there's a few considerations that I would ask the court to impose, and the court has made the compassionate choice in the past with the attendant circumstances that have been set forth of, look, if it really looks like this car is going to be damaged or vandalized, then we'll take it to protect it. But if protection is really the byword in that test, I would ask the court also to include protection of a citizen from this really excessive, not only the pretextual search, but this excessive expense that a vehicle impoundment can result in.
But you're with all due respect, I've asked, just as Ireland has asked, we're looking for what you say is a viable rule. The police may not impound a car until they have done what? I assume at some point they are permitted to impound the car as opposed to leaving it indefinitely on a city street without necessarily even notifying the owner. I mean, how is she supposed to? I guess you expect Eddington to call her up and say your car is on this street?
Well,
Are the police supposed to sort of assume that will happen and just to leave a car there?
Well, I think. Well, first of all, the car was legally parked in a spot on a public street. The police even said that. So I don't think it would have been a problem.
Well,
and
it was according to the facts that the officer knew that there had been 2 murders, shootings, fighting, public drinking outside this area, and illegal parking problems. So,
well, that was near the house that they were observing. By this
and how
time,
far was this from the house?
It was at least a few blocks, because the testimony was that they followed him to the corner, that he took a left, and then he took another left. And they activated their blue lights at some point after that.
It was definitely not a parking place of the driver's choice. The driver was pulled over, so it wasn't like I parked in my neighborhood.
I made a mistake about that in my application for further appellate review, because that was the distinction that the appeals court made between this case and Brinson, where in Brinson, the defendant chose his parking spot. In this case, it was the parking spot.
It was also the defendant's car. I mean, doesn't that make a difference?
Well, I don't understand why, again, I don't understand why there's this push towards impoundment. Why is impoundment so great? I mean, impoundment carries probably as great a risk of some kind of damage to the vehicle or loss as leaving it on a sidewalk. And the other reason, and I apologize for not being able to.
Why does impoundment carry a risk of loss?
Well, just in the, I think that the more a car travels, the greater the opportunity for some kind of damage. When a car is hooked up to a tow, when it's taken to an impound lot, things can happen. I don't think that an impound lot is necessarily going to be that much safer than a public spot on the street. And my answer to the question of, well, what should this bright line rule be? Well, I was really hoping that the court would come up with something.
So what would the police do? So let's assume the car was left there and it was vandalized. So the owner says, "Excuse me, Mr. Officer, you arrested people in my car that didn't have a license, that weren't me, that didn't have a registration, that were out drinking, and you just left the car on the street there? You just left it there? You didn't?"
I think she'd probably go to her insurance company first. I really don't think that. The way
assuming she can find it.
Yeah.
I really don't think that the police are in for it the way that it has been characterized in the past. But I do want to also make the point that this was February, and so to send a person out, not in the city where there's public transportation, to send a person out looking for a car in February. They don't even know this person. They didn't try to phone this person. I think that if a bright line rule were established, it would help the police make the correct decision at the time on the street, so that, because once it gets to the appellate level, the financial damage has already been done. It would be nice if that decision, if that bright line rule could incorporate some consideration for the other impacts.
You mean the impacts on the owner?
The impacts on the owner of the vehicle. Because, as I said, life is going to continue for most people after an arrest, unless it's a very serious crime.
They're still going to have to get to work. They're still going to have to
I
take
thought
their kids to
impoundment
school.
was essentially all about, or largely about, protecting the property.
Well, I think
the
that,
owner.
well, I think that the flip side to that is sometimes do me a favor, or as the amicus brief said, in this case, the police did the vehicle owner no favor by towing her 1999 Nissan Sentra. Sometimes it's just do me a favor and leave my car there. I will take care of it. I think a citizen is better suited to make those arrangements than the government. I don't think that we need the government to do all those things for us.
Right, thank you, Counsel.
Thank you.
May it please the Court, my name is Thomas McGuire. I'm from Springfield, and I represent Jessica Kappas, who is the co-defendant and the front seat passenger.
You didn't seek further appellate review, is that right, Mr. McGuire?
I did not.
So, do you think you have a right to ride on Ms. Contertesi's coat?
I would hope so. I think I have some things to add.
But let me just ask
Because
you
it
this.
was granted, I assumed that it would be for both defendants.
It isn't on the civil side. On the civil side, every party who is seeking further appellate review has to make the application for further appellate review. Shouldn't the rule be the same on the criminal side?
No, I don't think so.
Why?
Because they stand sometimes in different positions, and if the court is going to look further at another decision, the decision of the appeals court, then they should look at the entire decision as it affects each defendant.
Even if defendants who may have different claims, some different claims, don't bother to appeal?
Yes, under the circumstances, because what this court is saying is there's a question as to the appeals court decision.
So you're saying they're similarly situated and it should be treated the same?
I'm saying that they each have they are similarly situated and they should be treated the same. When you look at Ms. Kappas, once the car was stopped, Mr. Eddington said, "I don't have a license." So what can the police do? They can issue Ms. Kappas a citation for an open container violation. They can issue a citation to Mr. Eddington for an open container violation and driving without a license. But then further investigation reveals that his license was suspended. So he's not going to get a citation now. He's going to get an arrest. She, when they find out that he's under arrest, should be given the citation and said, "Go along. The car's not going anywhere."
So she's really got different issues than he does.
She does have some different issues and some
But you
the same.
didn't raise those with us. I mean, you didn't raise those in any application for further appellate review?
I did not. And I suggested the court should hear them anyway, because they are in the same position in terms of the effect of the appeals court reversing the decision of the motion judge.
No, the only way they're in the same position is they both lost. I mean, they have different legal issues.
There are some of the same issues and some of and different issues, but the basic issue is the same. Did the police have a right, and it's a factual analysis, to impound that car? Community caretaking function is constantly based on facts. So I don't think this court can lay down any black letter law that to impound the car under community caretaking functions, you must have 1, 2, and 3. Because in this case, if the owner of the car was the driver, he would have had the authority to say, "Leave my car. It's locked, leave my car."
Right?
But this isn't the driver. This is
Correct.
the owner that they don't know where she is.
Right.
They're on
So
the
doesn't
street
that-
and they have a
doesn't that-
name.
Doesn't that argue in favor of impounding it?
No, it doesn't argue in favor of impounding it because it's 4 o'clock in the morning.
Mm-hmm.
It's in an area that is single and two-family homes with multiple on-street parking. They have no information.
Is that in the record? Is that in the record? That
Yes.
Single and two-family homes with multiple parking?
Yes.
Okay,
So what should the police have done? You say just leave
Left it
there?
alone.
Should they have contacted the owner?
Of course. But they would do that through police headquarters, through their dispatcher, and they would probably do it at 6 or 7 in the morning, saying, "By the way, is this Miss Rodriguez? Your car was stopped last evening. It is located at such and such Suffolk Street. It has been locked. The keys are at police headquarters. Please come and pick them up." Because at that point in time, there's no issue in terms of a real danger to the car. The information they give about the crime in the area is all on Wilbraham Road. Now, Suffolk Street is a small residential street. Wilbraham Road is a huge road. There's a house there that they've known for a long time is the scene of many after-hours parties, all kinds of other events. But on this particular evening, they watched that house for a substantial period of time. 2 people left. Those 2 people were each carrying a bottle of beer. Now, their intent in watching that house ended when they decided to go after 2 people with open containers of beer. They didn't even know when that car that these people were in left the parking lot across the street, because their vision was shielded by a set of bushes, whether they'd left the bottles of beer on the parking lot ground and left without perhaps empty bottles. So they went, followed the car. They had the right to stop them. That's what Judge McDonald found for the open container violation. And when they approached the car, okay, they see the 2 open containers. So their stop is a good stop.
Your time is up.
Thank you.
May it please the Court, Thomas Townsend for the Commonwealth. There was no evidence about on-street parking available, ample on-street parking, or that there are 1- and 2-family homes.
No, was there any evidence that there were car thefts in this area, or vandalism, or anything other than the characteristic of it as a high crime area by one of the officers? I have to say, we see cases here all the time. I think all of Boston is a high crime area, depending on how you define it, but that's what everybody says, because there's crime.
Well, there was testimony that the area where the stop was conducted was a high crime area, and the judge so found that it was a high crime area.
But the car wasn't parked where
it was around the corner. What happened was that the car, as it exited the parking lot next to the church, took a left onto Wilbraham Road, then took a right onto Suffolk Road. It's around the corner.
But you know, at least from Boston, that a few blocks can make a big difference in terms of whether it's a high crime area or not.
Right, but the judge did find it was a high crime area. It was around the block from
Judge, I thought, found by his own experience, by his knowledge of the area, that it was not a high crime area.
Well, he credited in his statement of facts that it was a high crime area. He said from his knowledge of the area that there were 1- and 2-family homes. It was a residential area, which it could still be a high crime area.
But
and
that,
there
was that evidence, or was that from his own prior knowledge?
His own prior knowledge that it was a residential.
Well, that isn't really appropriate, is it? That he
Well, that's the
his
Commonwealth's.
own
That's
knowledge?
the Commonwealth's contention that to characterize the road as a residential area is improper because there was no evidence admitted at trial that it was.
Couldn't he take judicial notice of that?
Well, that's what we're contending that he could not. The judicial notice is proper in 2 circumstances: when there is common knowledge, water is wet, or there's generalized knowledge that can be readily ascertainable from authoritative source. This happened in April, not in February, April 29th. We don't know what day it was, but we can refer to a calendar, which is an authoritative search, and know it was a Sunday morning. That would be a proper exercise of judicial notice, not whether or not there was a lot of on-street parking or this was a residential area. That may be known to the initiated, but that's nothing that we can verify.
Your argument then is that if somebody goes before a judge and says that Commonwealth Avenue in Newton is a high crime area, and the judge knows the area and therefore does not credit that information that it's truly a high crime area, the judge can't do that.
No, the judge is limited to the facts. He may not credit for other reasons. Did not find the person believable.
But the fact that he knows but I mean, a juror in a case could, based on their own common experience, not credit testimony based on their common knowledge and experience. Why can't a judge?
Well, I think the judge is limited it's a matter of fundamental fairness to both sides. It's limited to the evidence that is introduced at the hearing. Unless perhaps the fact that American International College was nearby. That perhaps is ascertainable and verifiable and proper for judicial notice. But the fact of whether it's a residential area or whether there's ample on-street parking, the character of the homes, the character of the neighborhood, I think that's improper and unfair to the Commonwealth. The defendants had opportunity to put on their side of the case, and they could have solicited such information.
But what if the judge simply said, I don't credit the testimony of the officer that it was a high crime area and didn't go on to explain his reasons. Would you say that's inappropriate, even though the reasons for not crediting are the same as the ones he in fact articulated?
Well, I think we'd be in a bind because there's no way that we would ascertain his mental processes.
Okay, so the rule then for a judge is just don't write down.
Well, no.
I think it's okay as long as you don't write it down.
I think if the judge had a problem in that the evidence, conflicted with his or her experience, perhaps the judge should not be hearing the case.
Every judge, that's going to be pretty restrictive for judges who happen to live in a town and therefore know the area.
Well, when it comes down to something with like the character of the houses, the character of the neighborhood, distances are proper subject to judicial notice. But the appeals court in the case, which I cited in my brief, said, for instance, a school, whether it's a vocational school, elementary school, or high school, that can be ascertained, but that's not a proper subject for judicial notice. A judge may know, well, that's an example would be satisfying an element of the offense. Well, I know from personal experience that is a grade school and therefore satisfying the school zone element. That would be improper to the defendant.
But all he did was say what one could observe by driving down the street, not necessarily. But he says basically, I know the neighborhood. I think he said I drive by there all the time.
Well, he took that knowledge and he used it to discount the officer's fear, which he did credit in his statement of the facts, that they feared that the car would be vandalized or stolen if unattended.
Could we follow up on that? Is the Commonwealth's position that in a high crime area that a car would always be would be the subject of vandalism? Does that mean that in a high crime area a car can always be impounded?
No, I don't think that is that would be
Why
proper.
not?
The thing that distinguishes this case is that the owner was not present. Most cases, the driver is the owner, and the driver knows, number one, where he or she left the car, and number two, that they would be able to, they would have the authority to drive it, since they're the owner, and they'll have the knowledge about where to find the car. Here it's different. Here, Mr. Eddington was not the owner of the car. He was the driver. He was arrested. It would be unwise for the police to leave the keys in the ignition and lock the car. That would be negligent. What the defendants suggest is that the police safeguard the keys and try to track down Ms. Rodriguez. We don't know anything about Ms. Rodriguez. We don't even know if there was a phone number available. The judge in his legal section said it was not clear whether there was a phone number available. Even if there was, there's no indication that it was a current or up-to-date phone number, that she was in town or out of town. She could have been back at the party. It's not known. So the officers, they were due to change shift at 7 o'clock. So there would be new officers who would have to track down Ms. Rodriguez and to try to tell her, well, your car is on Suffolk Street. We have the keys. It's a lot to put onto the police.
Well, what
burden.
if they impound it? How does Ms. Rodriguez find out that it's impounded?
Well, presumably the tow company is in the business of safeguarding the cars and notifying the people of the whereabouts of the cars. It should not be the function of the police.
Do you find that often happens when your car is towed, that you get a phone call from the tow company saying, "Hi, we have your car," or do you wander around saying, "What the heck? Where is my car?" and you're calling everybody?
Or the burden is on the person to contact the police and then find out that it has been towed.
That would be true whether you impound it or not.
Right. Well,
the burden might be on Ms. Rodriguez to contact the police whether it's left on Suffolk Street or it's taken to the impound lot.
Right, but the police, the whole purpose of impounding is to safeguard the car. And I don't think that distinction should be made about the make or model of the car, which, by the way, is not in the record presented to this court. It may have been on the tow sheet that was available, but that wasn't included in the appendix to any of the briefs. The amicus brief says it was a Maxima. Sister counsel says it was a Sentra. But it shouldn't matter whether it was an old car. I drive a 95 Geo. I would want that treated with as much respect as a $40,000 Lexus.
And would that mean that the respect that you would think you're entitled to is a telephone call to say, your car, it has been stopped with persons who have been arrested. What do you want us to do with it?
Well, not necessarily at 4 o'clock in the morning.
Okay, so 6:30. Well, would you prefer your car be towed as opposed to the inconvenience of being woken up and saying, we have your car? I must say, I don't generally see the police being so respectful of people's sleep as they appear to be here. We hate to wake her, so we'll tow her car.
Well, number one, we don't know if we had a phone number, but even if we did, the appeals court confronted a similar situation.
But I guess is it not a fair? I mean, I know that for some reason the defendants here don't wish to offer us any rule, but why should the rule not be the police should attempt to notify the owner, and if they cannot because the person doesn't answer the phone, then they can tow it. So, but here there was no evidence that they had made any effort to notify the owner and obtain the owner's guidance as to what she wants to be done with it.
Well, again, we're assuming there was contact information available. But again, to what extent?
Isn't it your burden to show that there was not? I mean, it's a different situation if you say we knew nothing about the owner, we couldn't contact her, and therefore we were faced with the prospect of having the car be there indefinitely, and so we towed it. That's a different story from we didn't make any effort to reach her and ask her what she wants.
Well, under the appeals court precedent, the Henley case, which the motion judge did cite and follow, that the police not required in the middle of the night to try to track down the owner, even through a phone call. But even if we take that a little bit further, are the police thereby required to pick her up because her car, after all, is not with her? Are they required to safeguard the car, stand there, go and pick her up and bring her to the car, if they could even contact her? I think it's a lot to put on the police who have just made a significant arrest. They have 2 arrestees, a loaded gun, and they want to move on to other business and process in the arrestees.
But I mean, if the person was in the car, if it was his car, they would say, what do you want to be done with the car? And he would say, either lock it up and I'll pick it up, or tow it. So why doesn't she, who was not placed under arrest, get the same respect? So to call and say, what do you want to do with the car? And she either says, leave it there, and they leave it there, or tow it.
I think the difference should be made and a line drawn between whether the owner the driver is the owner or not. If the driver is right there and can be asked, and if it's not legally parked, there's a passenger there who has a license who, with the owner's consent, can take the car. That's one thing. But another thing to have it at 4:30 in the morning, we don't know if there's contact information. I think it's unreasonable for the police to try to track down. Perhaps I would have appreciated a phone call. Sure.
May I ask you, if this had occurred at 4 in the afternoon, would we have a different result?
I don't necessarily think so, because I would, if the court is asking me for a proposed rule, the rule I would draw is whether the owner is present and available.
Well, you seem to suggest the time has some significance.
Well, I think the time makes it a stronger case. I don't think it's a dispositive consideration.
So I'm asking you a hypothetical where the time is not an issue.
Even if we took the time issue away, I think we still have the burden we're placing on the police to go and contact the person who may be miles away, could be out of state, and try to make arrangements with them after they had made an arrest. I think it's not a burden to place on the police when it's much easier from their end to safeguard the car through towing it.
So under your rule, if my son were to drive and be arrested, which I hope he will not be, and it's my car, they tow it. They don't call me, they just tow it.
Well, I'm sure you would appreciate, as I would appreciate, a phone call in those circumstances.
But you're saying there's no obligation. They can just tow it.
To constitutionally require the police to be proactive and call the owner of a car if they have the number. I don't think that's a constitutional requirement.
Okay. Well, the question is reasonable. I mean, the police, do they have a reasonable basis to believe that the car might be damaged? And part of that, I suspect, is sort of if they have the ability to contact the owner, but they just don't want to do it, is that a reasonable assessment of the circumstances? I mean,
I think the reasonable situation should be on the ground, whether owner is present or not. Where the time factor may come into play is that in the middle of the night there may be more likelihood that the car would be vandalized, as opposed to 4 o'clock in the afternoon. It would be less likely. That's maybe where the time factor would come in, and a middle of the night decision to tow may be that much more.
In addition to the expense of towing, I mean, what we are talking about here is an impounding a vehicle, which means an inventory search, which means the whole car is opened up and everything's taken out, and that's a pretty big invasion of one's privacy. So there is a fair amount at stake here. It's not just we're going to tow it to the lot and keep it safe for you.
Right, and the impounding is to protect the police from claims of
The inventory
from false
search.
claims. The inventory
is to
search.
protect the police.
And also to protect the driver, the owner of the car, to make sure that their possessions are there and accounted for when they're towed, when the car is handed over to the tow company. So it's to protect both sides there.
So there's a substantial policy to protect the police when they impound cars. The question is, shouldn't there be a reasonable policy with respect to giving owners notice and options instead of having them go through this very elaborate, costly process?
Well, of course, it would be advisable, it would be a good thing for the police to call. But I think if it were a constitutional requirement, then we're looking at all sorts of different scenarios. How far away does the owner have to be? Is a 5-minute walk close enough? If they're a half-hour away and think they can get a ride from a neighbor, those cases will arise. The time of day would be a consideration, the weather outside. There's all sorts of weather.
Why is that? Why can't they just call the owner, and if they can reach the owner, say what he wants to do? Do you want us to lock it and leave it, or do you want us to tow it? That's all. If he says lock it and leave it, the police can write down, he said lock it and leave it, it's no longer their responsibility. Why must they go into 1,000 different...
Well, I think if that were to be the policy, that should be a policy that pertains to the police department tow policy. I don't see that as a one that should be imposed upon them based on constitutional requirements.
Well, the Constitution does impose some obligations.
I agree with that, but in this context, especially since the owner is at that point not a defendant, I think it's an added burden to the police. And I think it's not required, or just not to require it in these circumstances.
Thank you very much.